medicine, there's a moment that defines everything. It happens in a quiet space between a doctor's recommendation and a patient's signature. A moment where trust, information, and autonomy must align perfectly. That moment is informed consent. It is the legal and ethical foundation that separates healing from harm and permission from violation. But what happens when there is no time for that moment? That is exactly what we are trying to resolve in this podcast. I'm Wilson Changlairawan, and I'll be your host today, accompanied by my colleagues. Today we're stepping into one of the most ethically charged places or spaces in healthcare, which is consent in emergency situations. This topic contains three main discussion points which we will explore each in turn. First, the action-first dilemma led by Felicia Atmapralieto. Second, the case study led by Noah Nathaniel Lim. And thirdly, the application of the guidelines led by Ofra Hasa Hasipo.
So, in emergency situations, do the medical personnel act or ask for consent first? I would imagine that it would be difficult to ask for consent in such an urgent situation.
Well, that's correct. That is why we have the Indonesian Ministry of Health Regulation number 290 year 2008 on medical action consent. In Article 4, it is stipulated that consent is not needed in emergency conditions. The patient's life is priority in those conditions. However, these calls can only be made by the doctor, and the act must be informed as soon as the patient is awake or to their families.
Why is that? Isn't consent important?
Well, it is, but in situations as such, Dr. Wahyu states that it activates the life-saving doctrine. This doctrine was coined by van der Mijn as the action functions to save the patient, so ideally, it is a win-win situation. This is also supported by Article 275, Paragraph 2 of the Health Act.
So, are there any actual negative effects of this?
Well, yes, as it establishes an unequal relationship between the doctors and their patients, as stated by Hadi Zulkarnain and Zainal Hussein. It creates implied consent, where the patient is deemed to have implicitly given consent to the doctor, and it creates a less collaborative environment.
What if the patient or family actually disagrees with the medical act?
It may lead to disputes with an argument of informed refusal. Dr. Wahyu states that informed refusal is the antithesis of informed consent. That is an implementation of someone's right in self-determination. But in Indonesia, this argument only applies to non-emergency situations. But maybe one of you guys know a case about such situations?
You're absolutely right. Indonesia has several cases where emergency consent was a vital part of the dispute. One of these cases comes from the District Court of Tangerang's decision number 1324 of 2021.
So what exactly happened in that case?
That case itself concerns a husband who refused to consent for an emergency cesarean section because he believed that his wife was not in a critical condition. Despite this refusal, the doctors and the hospital proceeded with the emergency treatment anyway. This was because they considered immediate intervention was necessary to save the mother and the child.
Should this be allowed?
Well, in certain contexts, such as emergency situations, informed refusal may be bypassed by the life-saving doctrine.
Oh yes, I've heard of this doctrine. If I remember, this doctrine was proposed by Professor van der Mijn, where he states that in emergency situations, the primary basis for medical action taken by doctors is the preservation of patient's life.
Yes, exactly. It is under that exact doctrine where a widespread debate arises between the value of the patient's consent and the doctor's determination of emergency situations.
So what was the result of the case that you mentioned?
While the case itself never passed into the substantive phase concerning alleged malpractice itself, the court found the case to be formally flawed and ultimately found that the claims were completely inadmissible. Despite this, the case provides an insight into the highly volatile, case-by-case sector of health law. Despite this, though, the government legislation has attempted to set out certain guidelines to ensure that cases of this nature are handled appropriately at a judicial level.
In Indonesia, how are the guidelines on informed consent in cases of emergency?
Regulations like Law Number 17 of 2023 on Health and Minister of Health Regulation Number 290 of 2008 on approval of medical procedures can be seen as the primary regulations and instruments.
Can you emphasize the relevant provisions?
Sure, interestingly, both regulations regulate them under Article 4. Article 4 of the Health Law guarantees patients the right to choose health services, except in emergency situations. Meanwhile, Article 4 of the Minister of Health Regulation states that consent is not required in emergency situations when immediate treatment is necessary to save life or prevent disability. In such cases, the decision must be made by authorized medical personnel, documented in the medical record, and explained afterwards once the patient regained consciousness or to the immediate family.
I see. Are those provisions supported in theory?
Actually, yes. As Noah mentioned before, the reflect life-saving doctrine introduced by Van der Mijn, as well as the principle of Zakwarneming under Article 1354 of the Indonesian Civil Code, which was basically means the law assumes the patient would authorize urgent treatment to save their life.
Now, even with those provisions, can disputes still happen in practice? And would you say the current guidelines are clear enough for frontline practitioners?
Overall, I believe so. The rules are legally clear and realistic enough because they prioritize life-saving action. But disputes remain possible due to different interpretation of medical urgency or just the overall complexity of the situation, which is why proper documentation and communication are essential and stated as requirements.
With this, I believe that we have concluded this podcast with fruitful results. Firstly, the action first dilemma is resolved by the life-saving doctrine, which allows the inference of implicit consent, supported by the Health Act. Secondly, the case study clarifies that the life-saving doctrine prevails. And lastly, the government has enacted a guideline to further regulate this entire issue. Accordingly, we thank this audience for paying due attention to our podcast, and we hope that this will be helpful guidance for all of you.